Hi, I'm Warren Reid. This case involved one of the world's largest vehicle dispatching organizations, the dispatcher, and complicated computer-aided dispatch systems called CAD systems, which included first-time use of mobile data terminals and GPS in every patrol car. The system had to handle hazardous situations, assist local police department dispatching, and needed to be redundant and fault-tolerant during critical needs situations such as earthquakes, tornadoes, or other disasters. The opposing party, the Integrator, a billion-dollar-plus consulting firm, rightly believed that integrating this particular CAD system would give it worldwide renown and instant credibility. The Integrator sued the dispatcher for over $100 million, though the contract was only a fraction of that, charging that the dispatcher's unreasonable contract termination negatively affected their future business worldwide. Among other things, they sued for future profits lost. The Integrator further blamed its inability to finish on the dispatcher's alleged reluctance to freeze specifications. Despite this, the Integrator claimed to need only a few more weeks to deliver a fully tested and functional system. With a review of tens of thousands of documents and interviews with dispatcher employees, we concluded the project was horribly underestimated. No formal estimating methodology was used. Furthermore, we believe the architecture was wrong from the beginning. The otherwise experienced Integrator grossly underestimated and understaffed the critical path part of the project. The Integrator was unaware of the user's needs. The Integrator claimed to be an expert or have available expert subcontractors in certain required functionalities. We believed those functionalities were manifestly evident or, as a CAD expert, the Integrator should have known about them. Burying its head or calling each requirement a change was no defense. Project management tools were deficient. While the submitted work plans and work breakdown structure appeared to be adequate, the project staff did not charge their time properly to task levels. Automated time and project management tools were of little value if the data was incorrect, late, or incomplete. The staff was unfit, inadequate, and poorly managed. We found letters showing the lack of a chief engineer and high turnover among senior software analysts. We noted staff being pulled off of the job to work on other jobs that the Integrator believed were even bigger emergencies. On December 24th, one of the key testing managers quit the company, and we discovered what we hoped would be a smoking gun. A personnel evaluation letter stating that the manager was in over her head without adequate training or support to handle this size job. However, opposing counsel responded that the letters were hastily drafted, the boss was distracted on Christmas Eve, and these sour grape letters didn't reflect the departing manager's work. The system quality was poor. Failure to use a formal or consistent systems development methodology exacerbated the poor quality. The lack of standards, plus ineffective walkthroughs during the requirements, analysis, and systems design phases meant the system was haphazardly pieced together, making thorough testing of failover and fault tolerance and other critical functions nearly impossible and maintenance very difficult, if possible at all. There was no formal testing organization, nor did management give the testing group the power to delay progress or halt the release of a defective product. There was no requirements traceability matrix, nor a standard regression test environment. Furthermore, test plans showed inadequate stress, fault tolerance, quality assurance, and bad data boundary tests. The Integrator tried to tell the court that a fully functioning system was just around the corner. We reviewed the design in detail and concluded that the only way to make the system perform reliably was to start again. The Integrator company was an employee-owned company in a city then experiencing a harsh recession. While the local jury said penalizing its own citizenry was extremely difficult, they awarded over $1 million to the dispatcher to cover attorney fees, from $100 million against to $1 million for, a stunning turnaround victory indeed.